But suppose no declaration is issued by Parliament in a law under entry 52
Yes.
in relation to an industry. Under what list will that industry fall?
No, it need not be, it not fall under any particular entry anywhere.
No, it has to
That's what
fall
I'm saying.
somewhere.
That's
It has
what
to fall
there's an
somewhere.
industry. Today there's an industry which is not in any other list or even
No.
or
So
not.
suppose there's no declaration issued by Parliament in respect of a particular industry A.
Yeah.
Where will it fall?
No, that inquiry, from my understanding, that inquiry may or may not be relevant wherever it falls.
No,
I'll just come to it.
relevancy we'll decide later, but suppose a declaration is not issued by Parliament.
If a declaration is not made under entry 52 list 1, then entry 24 will certainly operate.
Right.
That's not the problem. But the question is, entry 24 operating ex proprio vigor, right? In the absence of a law under entry 52 list 1, that may have no relevance to what the Parliament can do in entry 52 list 1. It may be an industry under 24, whatever be the industry. But 52 occupies an entirely different, issue altogether, subject altogether. So whatever be the industry, can Parliament not control it? So it is not it is the nature of the industry, I said, the various purposes that will be served by controlling the industry. The moment you enter into discussions on what are the other entries in state list, which may have a bearing, a relationship or otherwise with entry 24, and therefore will it control entry 52 list 1? I think that's a long line of inquiry. We begin from a wrong side. This is untrampled, as I said. So if tomorrow Parliament says, I don't need an Industrial Development Regulation Act, and so be it. But as long as the law occupies the field, and Parliament has continued to say, well, I will insert various industries in the schedule, it evinces an intention to have a union control principle in position and to bring in from time to time industries within the schedule. Please come to page 3 then. Proposition number 2. Certain entries in Schedule 7 constitute a family of entries in as much as an element of interconnectedness between them exists. Entries falling within such a family cannot be seen in isolation, and in a sense they are complementary. Entry 52 list 1 and entry 33 list 2, 3 should be, is such a family of special class. The principle of control enunciated in entry 52 of list 1 can also include and touch upon all matters relating to an industry that is brought under union's control. These matters can be production, trade, commerce, supply, distribution, etc. Depending upon the nature of the industry to be controlled and the public purpose such control of the industry will serve, Parliament can deal with any one or more or all of the above mentioned aspects of the industry. To the extent that the Parliament may deal with these matters, the competence of states to legislate under entries 26 and 27 of list 2 will be excluded or deluded. Entry 33 of list 3, however, is a coordinating branch of the principle of control. Trade, commerce, production, supply, and distribution of commodities or products are interconnected aspects of an industry. Entry 33 contemplates that Parliament will have the primary competence of legislating in relation to any one or more or all of the above matters as may be deemed necessary towards the control of an industry. The primary competence dimension flows from the control aspect, the foundation for any further legislative exercise. Depending on the scope and extent of parliamentary legislation, providing for control, the subjects which are not occupied by parliamentary law will be available to be dealt with by the states. When I say the primary competence of legislating, therefore, entry 52 flows into entry 33. Then, para 5, the view taken in paragraphs 14 and 15 of CL was Union of India, suggesting that a division between entry 52 list 1 and entry 33 list 3 does not offer a correct view on the reading of the above said entries. The aforesaid paragraphs are extracted here under. If you apply the same principle of harmonious construction to entries 24, 26, and 27 of list 2, the term industry in entry 24 would not take within its ambit trade and commerce or production, supply and distribution of goods, which are the express province of entries 26 and 27 of list 2. Stopping here for a minute, I suppose 24, 26, and 27 are a family of entries. 24 talks about industries. Once an industry, an industrial process, a production happens, everything thereafter is a continuum of an economic activity. For the purpose of felicitation and easy dealing with those matters, 26 and 27 are subdivided. Even if 26 and 27 are not there, 24 can still take care of all that under 26 and 27. Let me read paragraph 14 again. If you apply the same principle of harmonious construction to entries 24, 26, and 27 of list 2, the term industry in 24 would not take within its ambit trade and commerce or production, supply and distribution of goods, which are the express province of entries 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade and commerce in our production, supply, and distribution of the products of those industries, which fall under entry 52 of list 1. For the industries falling in entry 52 list 1, these subjects are carved out and expressly put in entry 33 of list 3. So what I find there is what I call the Berlin Wall. No. So 52 and 33 are so interconnected. They carved out, I say, for the facility of a state dealing with the subject. Let me read paragraph 15. In Calcutta Girls, the judicial court in Tikaramji was relied upon. Tikaramji is the case the court inter alia considered the interrelationship between entry 52 list 1, entry 24 list 2, and entry 27 list 2, and entry 37 list 3 as it stood prior to the amendment and as amended. This court examined the contention. The term industry should be widely construed to include all activities, including activities preceding production, such as acquisition of raw material, and activities subsequent to production, such as disposal of the finished products of that industry. Negativing this content in the light of the legislative entries, this court held that what would fall under entry 24 of list 2 would be the process of manufacture or production, except where the industry was a controlled industry, when it would fall within entry 52 of list 1. The products of industry would be comprised in entry 27 list 2, except where there are products of a controlled industry, and they would fall within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and entry 20 of list 2 would not be covered by entry 24 of list 2. And similarly, the subject matter falling under entry 33 would not fall under entry 52 of list 1. At one level, it is correct, but at a different level, it is not. Because the entry 33 is not about union control of industries. But what happens along with the union control is what is stated in entry 33. So union control must mean something beyond mere union control. It must mean the aspects and dimensions of union control. Therefore, I find in this reasoning in CL some kind of a wall of separation, which probably is not the adequate way of reading entries within the same list. Since I would like to make some submissions with regards what happened in Calcutta Gas. So if entry 24, 26, and 27, they all fall in list 2. So there is no need or a necessity for suggesting a conflict between these entries. They may overlap or there may be some distinction between these entries. In Calcutta Gas, what the court came close suggesting there's some kind of a conflict between antithesis between entries 24, 26, and 27, or gas works and entry 24.
27, they have to yield to entry 52 list 1 or entry 33
That's-
list 3 as the case may be.
That's true.
So they have to yield.
That's true. I come to it immediately. But what I'm trying to find out is entries 24, 26, and 27 in the state list. If I call them a family of entries, it's only a distribution of a certain dimensions or facets of economic activity amongst them. Industry, trade and commerce, supply, distribution, as I said, to repeat, a part of an economic activity and interconnected. Therefore, as I said, for facility, suppose you only want to do a deal with trade and commerce in an industry, you may do it under entry 26. You want to deal with supply and distribution, you may deal with it under entry 27.
Should be declared first. The entry 52.
That's right. As far as they are being subject to entry 33 is a different issue altogether. Because I had some difficulty in going ahead with the reasoning in CL. Therefore, I'll come back to it a little later.
33 list 3 is also with regard to a declared industry. That is the common thread.
That's right. That's right. Let me now continue to read at page 5, PDF page 5, paragraph 6. The reliance in the above judgment on Tikaramji for his conclusion does not seem to be correct. As stated above, entry 52 list 1 and entry 33 list 3 are two branches of one tree and they reinforce each other. On this understanding, the further conclusion that can be drawn is that it is open to the Parliament to enact in respect of matters relating to trade and commerce, production, supply and distribution, and also deal with the necessary elements of control and regulation touching upon the above subjects. The Industry Development and Regulation Act 1951 has enacted in respect of and provided for aspects of control and regulation touching upon trade, commerce, production, supply and distribution. For the purposes of exclusion of competence of states from entering into any one of the above matters, namely production, etc., it is sufficient that the 1951 Act has touched upon the area and the nature of control and regulation vis-a-vis the scheduled industry. Then a law is said to be complete and made insofar as it contains all the essential features of a legislation, including provisions in relation to delegated legislation. The mere fact that the details of the working of the legislation may be dealt with by way of rules, regulations, notifications, I was reading in paragraph 8.
Right.
Yes.
The mere fact the details of the working of the legislation may be dealt with by way of rules, regulations, notifications, and orders cannot be the reason for the assertion that the law is incomplete or that the field is unoccupied. The enforceability or otherwise of a law by reason of non-emanation of the subordinate legislation can have no relevance to the actual occupation of the field in question. It is the occupation and not its enforceability that matters. Not speaking at all or silence on a subject is different from the absence of measures towards enforceability of the statute. Then Tikaramji was a case dealing with raw materials not falling within the scope of the scheduled industry. It was in that context that the court noticed that no order was issued by the central government in exercise of the powers vested under Section 18G. Because sugarcane as a raw material did not fall under the scheduled industry, the court felt that possibility of an order under Section 18G being issued by the central government would not be enough. The case on hand is no parallel to Tikaramji. The entire fermentation industry has become a scheduled industry. After the amendment in 2016, one part of the fermentation industry, namely so-and-so, continues to be a scheduled industry. As a result, the subject matter of the fermentation industry as a whole or otherwise stands within the scope of the 1951 Act and within the details of Section 18G. It's submitted Tikaramji principle cannot be said to be a principle of universal application. That is, in the absence of an order under Section 18G of the IDR Act 1951, it will be a dormant law and the states will derive their competence to deal with any matters, all or any matters otherwise exhaustively dealt with by Section 18G. In other words, since the 1951 Act has enacted in respect to the entire spectrum of control and regulation, and also the details of their working. For instance, as spelled out in Section 18G, the said Act, there is no unoccupied field at all available to states. Then proposition number 3. Why entry 8 of list 2 cannot be of any avail to the states? The litmus test of entry 8 is from the point of human factors, namely human consumption. The word intoxicating must be seen only with reference to the impact owing to human consumption. That which is not consumable by humans will not fall within the meaning of intoxicating. Entry 51 talks about human consumption, but in a different context. I'll come to entry 51 in a short while. So notwithstanding the long history of definitions of liquor to include liquids with alcohol content, it cannot be canvassed that a human consumption part can be kept aside. All uses of liquids containing alcohol, other than meant for human consumption, would all fall under one heading of non-potable alcohol. Even entry 51 of list 2 talks about alcoholic liquors for human consumption. It's immaterial that there is no entry in the 7th schedule specifically designed as industrial alcohol. The 2016 amendment by way of substitution of entry 26 of the first schedule to IDR Act 1951 must be taken to clarify this position. The reason for focus on intoxication and human consumption is not far to seek. The manifold increase in the uses of alcohol-based products was neither known nor contemplated while legislating with reference to liquor, save prior to and at the time of enactment of the Constitution. The focus was on temperance, regulation of trade and commerce in humanly consumable alcoholic preparations.
Like an intoxicated bee.
Let's put some fireworks in the meanwhile.
Think of the bee and nothing else.
No, they deleted it.
These are like some footnotes.
It just fell off, on the table itself, it just fell off.
Yes.
So I thought that it was being a little heady with all those words. Today, when I made that comment of intoxicated bee,
Yes.
they thought that now the man has also become. Intoxicated by your arguments.
I think that is the intellectual stimulus rather than the intoxication. So you go heady sometimes by reason of the home state, the fire in the theater. You get intoxicated by some thought or an idea. So paragraph 4, the last line. The focus was on temperance, regulation of trade and commerce, and humanly consumable alcohol preparations. If I'm not wrong, therefore, I think when it is open to the legislature to pick up any of the definitions in various statutes, British and pre-independent, they could have fixed up liquor. If liquor conveyed the same meaning on various classes of liquids with alcohol, with different impacts, with different consumptions processes. I suppose in 1888, when the Spirits Act was there, nobody thought of using it for a toilet or a medicinal preparation the way we are doing it today. So the manifold uses which liquids of alcohol in different combination, strength, etc., can be made or put to use is something which emerging science and technology invents and discovers from time to time. Therefore, the Constitution could have said liquor, and it had the same meaning. But at some point of time, I suppose, when more and more understanding about the use of liquids containing alcohol come within the fold of experience, then it's open to Parliament or the statute authority to amend it, modify it, or in a given case where it's possible to give a meaning, as I said, telegraph includes telephone, the court may give a meaning. But where it is not possible, the court will not supply that meaning by itself. So it has to be based on the experience and knowledge which flows into technology and engineering and science. So that's why I thought our argument on reading entry 8 narrowly or expansively may or may not have any relevance on entry 52 list 1 and entry 33 list 3.
So we have to give a constitutional meaning.
Yes, yes.
A meaning within the Constitution means a constitutional meaning, not a meaning in the business sense or anything as such.
Correct. Let's try to take it a little further. So if I given a very narrow meaning to entry 8, to mean only that which is orally consumable. So that which is orally consumable can be an intoxicant. If you go back to the word toxic, even in Latin, toxicum, poisonous. But we can't go to that stage. So therefore, when all these legislation, the pre-British and the pre-constitutional legislation, they probably talked about what is the impact on temperance, oral consumption, what deleterious impact it may have on human consumption.
Meaningless at that way.
Therefore, it's in that context, regulation of trade, supply, distribution, etc. But even if we read it very widely, now because we are talking about manifold increase in the in liquids containing alcohol, even if you give that manifold, taking into account, give that very expansive reading, I say whichever way one reads that, it's immaterial for the purpose of entry 52 list 1 and entry 33 list 3. They cannot control what Parliament would say and how do I bring it within union control for what purposes. The entire argument is look at Calcutta Gas Works. What did it do? It kept gas and gas works out of entry 24. The same thing you should do as far as entry 8 is concerned. Entry 8 will have a very expansive meaning. Such a parallel, I think, is probably looking at the wrong side of entry 52 list 1. And therefore, I was trying to find out whether whatever be the concept of industries under entry 24, 52.1 is in a different footing altogether. But at the same time, there is some kind of a connectedness between 24 and 52 because they are talking about industries. So the industrial processes. So industry ultimately, whichever way one decides for the purpose of Industrial Disputes Act, or even otherwise, an organized activity by reason of which a product emerges. Something emerges out of an organized activity. That's why labor, capital, plus whatever one may call. So we have the theory of surplus value flowing from that only. So organized activity leading to emergence of a product or a thing or a matter. That's an industry. So when you want to deal with that as an economic activity, then I will look at various facets of that economic activity. So essentially, industry, in my understanding, is an organized economic activity, which is susceptible of being controlled under entry 24 and to a different level under entry 52, this one, because of a national considerations. May I just quickly, in the same volume,
Syrup which has
because even yesterday, sorry, Mr. Attar referred to a judgment to the US Supreme Court on intoxicating liquor. Earlier there was a Master kindly, I can hand over a copy. Only
constitutional sense.
the 18th Amendment was enforced between 1919 to 1933. You were copying that. If you have. Eighteenth Amendment, I don't have it. Let me just quickly read that. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquor. This here.
Oh, yes.
Manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territory subject to the jurisdiction thereof for beverage purposes, is hereby prohibited. The Congress and several states shall have concurrent power to enforce the article by appropriate legislation. That is what entry 8 is about. Then on the right-hand side, now we have the 21st Amendment. Some slight changes here. The 21st Amendment reads like this. The 18th article of amendment to the Constitution of the United States hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquor in violation of the laws thereof is hereby prohibited. So what the 21st Amendment thought was the relevance to beverages may or may not be relevant because it's talking about intoxicating liquor as the one common element both in the 18th Amendment and the 21st Amendment. I've looked into all those case law under the 21st Amendment. They all talked about various interstate movement of intoxicating liquor as beverages from one state to state. So the beverage idea is oral consumption of a liquor, wherever that oral consumption by an industrial process or by any human process makes it possible. At that stage, It is humanly possible to consume a liquor. At this stage, the intoxication dimension of oral consumption comes into play. Otherwise, why would you talk about intoxication at all?
So something which is used for industrial use cannot be a beverage, though it may be consumed otherwise.
There are non-intoxicating
It's
beverages.
not a beverage in the normal sense.
So we are not talking about non-intoxicating beverage, but in beverage, the moment it has an impact on human frame, mind, body, whatever you may call that. Therefore, the intoxication element is the only necessary and essential element of looking at entry 8. But as I said,
Beverage.
even if we give a very broad and expansive meaning to intoxicating liquor, taking into account the various classes of liquids containing alcohol, denatured, whatever one may call them, industrial alcohol, if we give a very broad meaning, even thereafter, entry 8 will not be a springboard for the state to argue entry 52(1) cannot indirectly come and enter into a field in state list. Then we will employ pick and substance, entrenchment, etc., etc. I don't think that's the way of looking at entry 52, list 1 at all.